too busy.
And so you have 4 minutes.
Okay, so what level of knowledge am I assuming?
I just told you.
Okay. Tell me when to go.
Go.
Okay, thank you for, good morning, Your Honor, and thank you for being here. We're here on plaintiff's motion to compel discovery of defendant Pittston. There are 4 items that plaintiff has requested of the defendant. Quick factual background, Pittston is a mining company that built a faulty dam in West Virginia. The dam collapsed, killing thousands of people. Our office represents the plaintiffs in personal injury suit against Pittston, and we seek to compel production of 4 pieces of discovery. The first, general counsel.
How do I have jurisdiction?
I'm sorry?
How do I have jurisdiction?
This is a federal proceeding because based on diversity. So we would like to see, I should go back. Pittston's president employed general counsel to investigate the failing of the dam. He prepared a general summary, including photos of the dam sites taken by Pittston employees and memos written by Pittston engineers as part of the investigation. I'm going to address these first 3 issues, first 3 discovery responses together.
Was that before or after the lawsuit was filed?
It was before, and that's a basis for compelling production. The summary, photos, the memos, they were all prepared in at the request of the president, but they were requested before litigation commenced. The first point I'll make is that the attorney-client privilege protects communications made to obtain legal advice. It does not protect the information underlying information communicated. Pittston counsel was collecting facts from Pittston employees to report back to the president before any litigation had begun.
Did they believe that litigation would begin?
I don't know what their mindset was.
Is that important to know?
It is not for purposes of these 3 things. And that, for the reason for that is because the report, the investigation, doesn't contain, or we don't think that it contains legal conclusions, strategies. It wasn't for the purpose of giving legal advice. This is no different than the tobacco companies of the mid-90s employing their attorneys to do research into the dangerousness of cigarettes and then hiding the dangerous memos under the guise of attorney-client privilege. Second, the privilege must give way for legitimate discovery needs. FR 26B3 says that otherwise privileged information is discoverable if the party shows it has a substantial need for the materials to prepare its case and cannot without undue hardship obtain their substantial equivalent by other means. There's no way that the plaintiffs can replicate the photos, can it obtain the information of the dam sites as they were based immediately after the dam failed. This would be included in the summary, this would be included in the engineer's memos. Justice requires production of these documents.
Is there a difference between photos and memos?
Ordinarily, I would say yes, but here, no, because the photos were snapshots taken of the dam sites, the memos written by engineers. The engineers were just snapshots of they're the factual basis on which the dam failed. It was just a recounting of the facts. The attorney-client privilege only applies to confidential communications between client counsel for giving legal advice. And recounting the facts doesn't, by virtue of it being created by the attorney, make it privileged.
Isn't all of this material being collected for the purpose of counsel being able to provide legal advice?
It is, but I would argue that because it's a simple recounting of the facts, it should not be privileged. And the final issue is production of all the documents related to the Pittston dams anywhere in the U.S. Unduly burdensome, possibly plaintiffs would stipulate to limit the scope to any documents that are germane to the litigation. And one final point is on the summarization, the photos of the dam sites and the memos written by the employees. Plaintiffs' counsel would agree to an in-camera review for your honor to determine whether or not they do contain legal theories and strategies.
How many
Those will be
documents
privileged.
are we talking about?
I don't know, I haven't seen a privilege log from defendant's counsel.
Why do you think that I have the time to review all that material?
My hope would be that in the interest of justice and in the interest of fairness, that defendant's counsel and I can work together to make the task easier for your honor to review and to make sure that this case is